Hello and welcome to the Daily Lawyer podcast. My name is Jana Krishnan. I'm the host and the founder of the Daily Lawyer.
As a professional, never identify yourself with a case. Your life is not just law. A good work-life balance. I think that's something that I picked up from him. And travel.
What would you say you've sort of picked up from him and how did that affect your career?
Unless you have definite knowledge, don't rely on press reports.
How did you advocate for Ram Lalla? What was that?
Because every attempt was being made to somehow or other delay the final hearing.
Now when we talk about cases,
What was done during the time of Babur was a monarch. It went on for 40 days and to build a masjid over an existing temple. That was not what was done by the people in independent India. If it is left to the engineers, irrigation engineers and agricultural scientists, a solution is possible. But if it is left to the politicians, it is not possible.
now sticking with advocacy, because you have, like you said, advocated in
As a lawyer, you are the boss. Not the ones which have had,
Not the eye-catching.
which have claimed the media attention.
I see. We did 5 productivity tips. Now 4 books that you would like to recommend. Need not be law books. It could be anything.
One is Tirukkural.
Tirukural. Oh, okay. I have a background in classical dance, not in music. But I really genuinely think that has really helped me as a person.
You may be arguing points which are completely unacceptable to the judge. Therefore, you will sometimes you face a hostile judge. If you don't take a risk, then move forward, and then that's that's a life lesson that I have learned.
Hello and welcome to the Daily Lawyer podcast. My name is Jana Krishnan. I'm your host and the founder of the Daily Lawyer. And today is yet another episode in our Legacy series. This series is conceived in collaboration with Solomon & Company, one of the oldest and most respected law firms based in Bombay, but they have offices elsewhere in India, and their legacy stretches across 4 generations and over 115 years. The Legacy series is our shared attempt to create a historical archive of conversations with senior lawyers, judges, professionals in the Indian legal profession who have left an indelible mark with their contributions to the profession. We hope to create this archive of conversations so that all of us can learn from it. We can dip into it for inspiration, for some sort of direction in our profession, or if we just want to spend an hour in the company of some really brilliant minds. With that, I'm so happy to introduce our guest for today, Mr. C.S. Vaidyanathan. Sir, thank you for being here. Mr. Vaidyanathan is a senior counsel with the Supreme Court of India. He was from 98 to 99 the first additional Solicitor General of India. Sir has advocated in landmark high profile cases, whether it is for Ram Lalla in the Ram Janmabhoomi case, Shabarimala, interstate river disputes, whether it is the Narmada river dispute or Kaveri, even interstate border issues between, I believe, Maharashtra and Karnataka, I believe, where the border has to be drawn, and the 2G scam. So I think most of the cases that have made headlines for days on end, I think Sir has played a part in it, and I am not going to spend too much time talking about it because we want to hear from him. So welcome to the Daily Lawyer podcast.
Pleasure speaking to you, Jana.
Thank you. But Sir, before we go into your cases, can you take us back to the beginning and tell us how did this start? Like, do you always want to be a lawyer? How did you get into the profession?
In school, I wanted to be an engineer. I found that my marks were not so high, and being a Brahmin in Tamil Nadu, unless you are in the top percentile, you are not likely to get admission, which I didn't have. And I didn't want to seek admission by paying capitation fee in engineering college. I went to do graduation in science, hoping that I'll switch over to engineering. But then I found that I didn't have much interest. So after that, I did law. I couldn't enroll after I finished law because I was 19 years and 7 months, and one has to be 21 years to enroll.
Oh wow! How were you so young that you finished?
I think twice I got double promotion.
Oh wow!
Those days it was possible, and therefore I could. I completed my school when I was just 13 years and 7 months.
Wow!
And therefore I couldn't get admission in Tamil Nadu. I went to Karnataka. I went to, at that time, Mysore. I did PUC in Sadhavilas College in Mysore. Then went to Bangalore, St. Joseph's College, did my graduation. So when I finished law, I had no option but to pursue either further courses, which I did. But meantime, I got a job in Delhi as a senior management trainee. For 3.5 years, I worked there. And that gave me an opportunity to visit Supreme Court and watch some of the star lawyers in action, including Palkiwala during the Keshavananda Bharati case in 72. And by the time about 3.5, 4 years I was in company, my heart was not in it. So then, since I had my legal qualification, I thought the best is to do law as a profession. And fortunately, I was able to join Mr. Venugopal in Madras as a junior in 1974, and that's how.
And you were with him till you became independent.
I was with Mr. Venugopal in Chennai from 74 to 79. When he shifted to Delhi as an additional Solicitor General, I went with him to Delhi. I continued in his office till about 83, 84 when I went on my own. But I have close understanding and relationship with Mr. Venugopal even today. I met him even last week. We have a perfect understanding.
Yeah. But he is like a legend in the profession.
Of course he is.
And I don't know, I think he's been involved in all of the biggest cases, I think, of independent India. And then Bhutan and I don't know, so many other places. But what do you, since you work so closely and in many senses he was your first mentor in the profession, and it's a very lucky place to be. So what would you say you've sort of picked up from him, and how did that affect your career?
First thing is, as a professional, never identify yourself with a case. And results should not bother you. Do your best, and whatever happens will happen. So don't be affected by the outcome of the case. I think that's one important takeaway from him. Second is, your life is not just law. Although law is a jealous mistress, your life has various facets. You see, he has always traveled. Every summer he is off somewhere. He used to travel. And he used to have multifarious activities, including listening to music, being part of international organizations, etc. Therefore, a good work-life balance. I think that's something that I picked up from him. And travel. So I have also been like him, traveling every year to various places, at least one country during summer, if not more. So that has been the experience, some of the things that one learns from him.
Yeah.
As for advocacy, I must tell you that one of the things that you pick up from him is, one, ethics. Being absolutely, upright and honest, and be frank with the court in regard to your case. Never keep back anything. Second, even today he is very particular. There should be no conflict of interest. If you are given an opinion to somebody, don't appear in the matter against them. If you have settled some pleadings, so always whenever any brief comes to him, he will first ask, have I in the matter been involved at any point of time earlier? This is something which I follow also. So I think today amongst the lawyers, he has a reputation for being absolutely fair. The judges will take his word in regard to facts. They will never question. And that's a kind of reputation that I would like to have, and I have tried to follow him as much as possible.
And now when we talk about cases, even you have been associated as an advocate in many of the headline grabbing cases. I'm not sure if this is correct, but I think were you associated in the Rajiv Gandhi
assassination case? I was
case?
appearing for in the Verma Commission and Jain Commission, and for the Tamil Nadu Police.
Yeah.
I think it was Justice Verma Commission of Inquiry finally concluded in the absence of anything else on receipts locutor. But yes, Tamil Nadu Police was in charge of security, and the incident happened in Tamil Nadu. Therefore, without even an inquiry, you can always fix the responsibility on them. But I personally feel that Mr. Raghavan and his team did the best that they could in the circumstances, and this was something, today so many terrorist attacks happen which possibly you can't sometimes prevent. And I would not fault the Tamil Nadu Police team in regard to the security arrangements. And in the Jain Commission, of course, the scope was the largest scope, and that was in regard to whether the LTTE was helped by any parties in Tamil Nadu, and one of the allegations that had been made that was doing the rounds was about...
Sir, can I pause you? Can you give a little bit of background for those who probably don't know? Because this probably happened at a time when a lot of our audience was maybe not even born.
On 21st May, I think, of 1991, during the election campaign, Rajiv Gandhi visited Sriperumbudur as part of the election campaign, and he was to address a meeting, and as he was going up the stage, he was offered a bouquet by a lady, and that contained the bomb, and the bomb blast took his life. A number of others also passed away. And this, of course, whether they were vetted from the point of view of security before being allowed into the meeting ground was the question that was raised in regard to that. And secondly, the larger issue of larger conspiracy of some political parties' involvement with the LTTE, because the person who caused this bomb blast, some links were found in regard to her being associated with LTTE. Liberation Tigers of Tamil Eelam. And therefore the larger conspiracy was probed into by the Jain Commission. And some political leaders had accused the DMK of being closely involved with that. So in fact, when I was appearing in the Jain Commission, one political leader, I don't want to name the person, wanted to say that there was some information in regard to the involvement of the DMK leader Karunanidhi. So I told that person, unless you have definite knowledge, don't rely on press reports. So that person was holding a very important position in Tamil Nadu. And the person was very reluctant to not to say that. So overnight, the person thought about it, and then I got a call to meet again, and then the person said yes, she will go by my advice. And that's how she kept away from naming him for any such involvement. But I think, of course, now that the gender is out, I might as well mention the name. It's Jayalalithaa. And Jayalalithaa, I think, is an extraordinarily intelligent person. Was an extraordinarily intelligent person. She was personally perhaps having some suspicion, but I said in the absence of any definitive material, you can't make such an allegation. And she finally accepted that and kept away from making that statement.
And then, I mean, I'm very interested in knowing about all of these big cases because, and I want to ask you another question about it from an advocacy perspective, but just like how you took us through a little bit of anecdotes where it came to this whole Rajiv Gandhi assassination case, which was perhaps a little earlier in time in today's context with our current audience. If we can go to the most recent, most like headline grabbing case of the recent 2 years, which is our Ram Janmabhoomi case. How was that? How did you advocate for Ram Lalla? What was that?
See, after the decision of the 3-judge bench in Allahabad High Court, the matter came to Supreme Court. All the parties had filed because the 3-judge bench in Allahabad High Court had really done panchayat justice, trying to divide the small bit of land into 3 parts, which was unworkable. And so all the parties, whether it was the Shaibites or the Hindus, the Muslims, everyone came to Supreme Court, and they were none of them was happy about the judgment. At that stage, I was approached. My wife was learning Sanskrit, so the person involved in the Rashtriya Sanskrit Samsthan, they approached me and said whether I will appear. I said I'll appear. That's how I got into the case, and I think it took about 11 years finally for the matter to come up, because every attempt was being made to somehow or other delay the final hearing. But finally, I think Justice Gogoi put his foot down and then went on with the case. It went on for 40 days, day to day, from morning 10:30 to 4. Some days they even sat late, and I think it was quite an experience. And Mr. Parasan was leading the arguments from the side of the Hindus, and because of his age, he told me that he will make preliminary submissions for a day and a half, and then he wanted me to take over and do the details in regard to the pleadings, evidence, etc. And that was, yes, it was a very good experience. I think I personally felt in a matter like this, and as Mr. Parasan himself says, we are mere instruments. So like that, I happen to be blessed to have been chosen to appear on the case. So I'm happy about it.
But I'm curious to know, and maybe I'm jumping the gun in for myself only, but it's in a case like this, which is getting so much of media attention is one part, but it's also deeply, the sentiments of people are very deeply engaged in this. How was that? What kind of pressure did that add? Did it add any pressure? And did your preparation, the way you address the court, it's such a fraught atmosphere. How was that?
No, I think preparation was over a period of several years actually. In fact, the archaeological evidence took a lot of time for me to understand. These are things which takes time to understand. And every year I come like this for Ayurvedic treatment. So 21 days. And those days I used to go to Coimbatore. Now I come here to Kerala. So the team, the lawyers team who used to assist me in preparation, they came from Allahabad and Delhi and sat with me when I was undergoing this treatment. And then we meticulously went through all the documents because it ran into some 70,000-80,000 pages. So to study that, it took time. And normally, whenever I take up a matter, I make it a point to go through the entirety of the brief, not selective pages which are given by the briefing council, but I like to go through the papers myself. So that's how this time was used by me in 1 or 2 years in summer vacation to prepare. And then, of course, we used to have frequent discussions with Mr. Parasaran and other counsel who had appeared, Mr. Narasimha, who is now a judge of Supreme Court, Ranjit Kumar, people like that. So we all used to meet and discuss. So, and we had a very good team of lawyers assisting. Mr. Bhupendra Yadav, who is now a minister, he used to be part of the team. And so we all used to sit together, discuss and prepare. I think, we have been able to make out an excellent case, and the judgment of the court, I am happy to say, was based on facts and law. And even though the government of the day might have been sympathetic, it was through the court process the success came. And that is something which we should be happy about, because what was done during the time of Babur was a monarch using his power as a king to take over land and to build a masjid over an existing temple. That was not what was done by the people in independent India. It was through the court process that the land was restored to, and the temple brought back to its original glory. I think that's an important message that comes out of this whole process, and that is how we intend pursuing the Krishna Janmabhoomi and Kashi Vishwanath temple cases also, in which I am both of which I am involved.
Okay, but sticking with temples, you are also involved in the Sabrimala case, where should women come, not come, all of that. How? I think my larger question is, when your religion is quite a polarizing subject, and in our country we all have strong religious views. How do you just not take the pressure, or in social situations, or how do you just manage to be neutral?
See, as a professional, we have to keep our set of personal beliefs and apart from the case, one. Two, I try to stay away from the media pressure as much as possible. Normally, I don't give any bites or go for any interviews. In fact, last 3-4 years, I've stopped watching TV.
Okay.
TV news particularly, because I think they are overly sensationalized, and it's not independent by and large.
Correct.
So I keep away completely from this, and therefore I'm much happier not watching the TV. I read, I think the print media is much better even today. I follow that. Yes, there is a lot of pressure. But I have broadly, people with whom I associate, Christians, Muslims, Hindus, I have friends of all hues. My friends may have extreme views, but we all talk it out, and I think by and large we are people who are able to agree to differ if need be. The pressure has never had such an undue influence on me.
And what about interstate disputes? Because this is one kind of pressure.
I think the interstate dispute is actually capable of being resolved even without the matter being taken to the tribunals and courts. But unfortunately, the statesmen who used to earlier prevail, like for example, I can tell you, Vamsadhara dispute. It's a river which originates in Odisha and flows into Andhra Pradesh. In 1960-61, the then chief ministers, who were statesmen, Biju Patnaik in Odisha and Sanjeevaya in Andhra Pradesh, of undivided Andhra Pradesh, they were able to agree to share the waters 50-50. Whereas in respect of Kaveri, Krishna, it has not been possible. Narmada also, there was a broad agreement. Narmada, there was an agreement even to, that of course was because of Mrs. Gandhi, and by and large it was the Congress government in all the states involved. She was able to prevail upon the states to even agree to give water to Rajasthan, which is not a riparian state of Narmada. So Rajasthan is short of water, even drinking water, and all the states, Gujarat, Madhya Pradesh, etc., they all agreed on sharing the waters with Rajasthan and have a separate canal, Indira Gandhi Canal, to take the water into Rajasthan. So they were able to do that. See, today there is so much of water flowing in Godavari, surplus every year, 1,500 TMC of water, which can easily be diverted into Krishna and thereafter to Pennar and to Kaveri. May not reach Kaveri, but certainly Krishna. But the problem is, if one party agrees, immediately the opposing parties will never will say that you are sold out. So that's a problem. Today, neither Telangana nor Andhra or Karnataka or Maharashtra are able to agree. Though I must say, in the first tribunal, all sides agreed at least on some of the major things. In Kaveri, that was not possible, and each state has a huge demand. But I must tell you that today the change in approach in regard to utilization of water is taking place in the mindset of at least the engineers and technique. If it is left to the engineers, irrigation engineers and agricultural scientists, a solution is possible. But if it is left to the politicians, it is not possible. And unfortunately, you can't have an agreement without the politicians being involved. In regard to the religious matters, such an agreement again, now in there was an attempt at reconciliation in Ram Janmabhoomi that didn't take place. See, the religious leaders again, they have their own constituency, and you find that see, if you go and see in Kashi today, you will find that the masjid and the temple are there, and if you have the prayers are not taking place in the masjid today, virtually. Hardly any involved. Therefore, nothing will be lost if that area is made available to the Kashi Vishwanath temple, and where, according to the faith and belief of the people, the Nandi is facing the Shivalinga, which presently, according to the faith and belief of the people, is in the area which is with part of the masjid. But and there is no particular significance to either the masjid, the Babri masjid, or this masjid in Kashi or Mathura, except that the then monarch, the person who some would call as marauders, who came in and then took over administration of the country. Once you come in, entire land is yours. You do whatever you want with it. That's what they did.
Symbols of your
Yes,
authority.
and so you capture that land and then you convert it. See, there is no significance. I can understand if you say Mecca, Medina should be shifted. No, nobody is talking about that, and there is no particular. Here, the people, therefore, for the Hindus, Krishna Janmabhoomi or Rama Janmabhoomi is of significance. Similarly, Kashi Vishwanath, people from all over have been going for a Kashi pilgrimage, and those in the days when if they go, one would not be sure whether they will come back. Both in regard to Sabarimala and Kashi Yatra, people were never sure that they will come back, and they have done this Kashi Yatra and Sabarimala Yatra in the days when it could not be accessed by train, bus or car, etc. Therefore, I mean, that shows the long held faith and belief of the Hindus, and therefore it is possible. If that kind of statesmanship is there, it is possible to solve.
Now, sticking with advocacy, because you have, like you said, advocated in public, you've appeared for the government, you've appeared for private parties in various cases, in various disputes. You've also appeared across multiple courts. How do you adapt do you first of all have to adapt your style of advocacy depending on where you are? And if yes, then how do you do it? Like if there's somebody who is listening and who wants to know, you were in Tamil Nadu also, in Karnataka also, in Supreme Court also, how does that work?
See, as lawyers, we are officers of court. So we have to be very fair and balanced, even ordinarily. But when you appear for government, the responsibility is greater. When you are a law officer, like for example, when I was an additional Solicitor General, the responsibility is even greater, because there are cases where if you find that there is justice on the petitioner side and if you are appearing for the government as a respondent, you have to concede. I think some of the best law officers have been those who have been able to see the justice and without having to address the court and then argue counter to the petitioner's case. If they themselves are in a position to concede and get the relief of the petition, that's the best thing. And I have done it several times as a law officer, and even as a lawyer when I appear for the government. That's one of the things that we always do, because as a government lawyer or as a public prosecutor, there is more neutrality and independence expected of you than when you appear for a private party. So that's a greater responsibility which you hold when you appear for the government. You are asking about appearing in various fora. Of course, today it has become easier. Earlier we had to physically appear. Today, with the virtual hearing hybrid facility, we are able to sit in one place and appear in various fora through the infrastructure which is available. Thanks to COVID, everybody has got used to that. And the government has also provided the infrastructure. Most courts are now having the facility to have hybrid hearing. I think, there's a lot of expectation when a counsel from Supreme Court appears in the high courts. Therefore, in terms of fair presentation, in terms of law, and therefore you have to raise up to that level and then making the submission. One thing that I have always followed, that my father, when I was thinking of becoming a lawyer, told me, as a lawyer, you are the boss. There is no boss other than you, above you. You are not in a master-servant relationship with anybody else. So you have to keep that in mind. You address the court with respect and regard. Give them the due to the institution, to the individual who is holding that office. But you don't subjugate yourself to a position. You don't have to be so submissive that you feel that you are kind of subordinate to him. So hold your independence, but be fair to the court. And that's as a lawyer, whenever you appear, keep that in mind. That's what I have done.
And what about they say a good lawyer is able to read the judge and read the read the room and so on. But how does that happen in a place that you don't know?
So you go and sit and watch for some time earlier, or you read up some of the judgments. When you appear in courts where you have not appeared earlier, I normally go sit in advance. Even if my matter is going to come up at 2 o'clock, I will be there at 10:30 to see how he conducts the proceedings. Does he read the brief in advance and come, or do you have to address him on facts and not just the law? Does he have an open mind, or does he have certain definite views? And that you also form. You ask the briefing lawyer. You sometimes read some judgments in advance delivered by him as to what his approach is, because you have to tailor your submissions accordingly.
Yeah. Oh, that's a good tip. I think I have just one question about that part where you spoke about being in a public office, in the sense representing the government as a public prosecutor, as an additional Solicitor General. Maybe if you can just clarify to the audience, what is the meaning of this position? What do they do?
See, there are some positions which are mentioned in the Constitution. The Constitution itself says, like Attorney General, Advocate General, Attorney General for India, Advocate General for each of the states. Other than that, there are other law officers like Solicitor General, Additional Solicitor General. Then you have the government leaders. Public prosecutor is again mentioned in the Criminal Procedure Code. And therefore, and the selection actually is to be done by the district judge in consultation with the government, or the government in consultation with the district judge. There has to be. So you are speaking as a representative of the public, espousing the cause of the public. You are not espousing the cause of any particular political party which is the ruling party of the government at that point of time. Parties may come and go, but governments are the bodies. Therefore, governments, there is a continuing body representing the interests of the public. So when you appear as a law officer, you represent the interests of the public. That's what you have to keep in mind, and not of the political party which is ruling the government at that time. This is very important. Therefore, that amount of independence must be displayed by you as a law officer. Any person who is holding the post of a law officer should always be independent and not toe the line of the party in power.
That is probably easier said than done, but I don't know how, it's difficult maybe to do, though that needs to be done. I think if I want to ask you, say, one concluding question to conclude the whole, when we are talking about advocacy and cases, when you reflect back on your years as an advocate, what would you say have been some of the most impactful cases, either some that you have done or something that just stands out to you? Maybe you were in the court around at that time, whatever.
Not the ones which have had, which have claimed the media attention.
I see.
According to me, the cases which have really given me a lot of soul satisfaction are number one, the cases which are done pro bono, without charging a fee. Not the cases which I have done on a professional basis. Of course, Ramlala case also I have done pro bono. So also Mathura and Kashi. some of the earliest cases, like Sebastian Hongre, that was in 1980s, before Desai and Chinnappa Reddy. That was a case of a Christian pastor and a headmaster in Manipur having been taken away by the armed forces, and they had just disappeared.
Oh.
And so a person, Sebastian Hongre, who happened to be from that village, came with that case and wanted a petition to be filed. A writ of habeas corpus was filed to because they were last seen with the armed forces. Where are they? So to produce them. So a mandamus was issued. A habeas corpus direction was issued to produce them. The government could not. Perhaps they had done away with them. And finally, after a lot of inquiry, contempt action, but for the first time the law was laid down that if such a thing happens, then our law, our constitution requires compensation to be given to the dependents of those people. And that, I think, has subsequently been followed up in a number of cases, and that's a very important thing, because prior to that, this kind of people disappearing, yes, armed forces claim that they have been taken away, and thereafter we have not done away with them. What happened, we don't know. But they are answerable. So holding them accountable, one, and two, to make some compensation, pay some compensation, though it may not compensate in terms of producing the person themselves, but at least a monetary compensation, some consolation. That was laid down. Second, the other case that I would say which gave me a lot of satisfaction was, see, there was a provision which said that if a person who is undergoing life imprisonment commits a murder, then mandatorily he had to be put to death, mandatory capital punishment. So this to me sounded somewhat arbitrary. And there was a case of Mithu where I had argued before a constitution bench, and the then senior Chief Justice Chandrachud accepted my arguments and said, yes, there must be discretion in the judge as to whether capital punishment should be imposed or any other punishment should be imposed, and therefore he struck down that law. And this was a colonial law which was struck down after, say, 100 years. So that was again of some significance. Thirdly, today we now talk about right to protest, right to speech, etc. One of the, I think, cases which might not have got so much publicity is in regard to the Frank Antony School. Frank Antony School was set up by Frank Antony, Anglo-Indian leader, and said it's a minority institution, and so the teachers had some grievances. So the teachers, during lunchtime, without interrupting their work, but taking off during the lunch break, had a silent procession, no noise, no disturbance of class. So the management of Frank Antony School suspended those people and said this is contrary to the school discipline. The teacher should not have done that. So the writ petition was filed, and Justice Chinnappa Reddy, who was heading the bench, he came down heavily on the school management and said, this is, see, our country was born by such non-violent methods of protest. We got freedom by such non-violent methods of protest, and how can you possibly, if they had kept away from classes, if they had interrupted the classes or interfered with the conduct of classes, you could have taken any action. But they are conducting the classes and cutting down their lunch break and using it for the purpose of protesting. How can you take any action against it? I think this is a very important judgment, advancing the right to protest and the freedom of speech by way of this protest, and wearing a black flag or having this ribbon on their clothes and protesting, an expression of speech. And therefore I think that's of course this was in the era of 1980s. So today these matters are covered on a minute-to-minute basis. These are not covered in
That's
that
true.
year.
When you told me protest and silent protest, somehow, those, maybe in this case it's also how to protest. Nowadays, not nowadays, but it often happens that the protest
Yes, I mean, like for example, lawyers, the constitutional bench has said that you can't indulge in a strike because that affects the rights of the litigants. People.
That's true.
Therefore, that's
you spoke when you were talking about what you learned from Mr. Venugopal. One of the things you said is work-life balance, and your life cannot be only about the law. You are also known to be very much of a music and culture, in the cultural arts, a lover and maybe a supporter of the cultural arts. How has that, has it, first of all, influenced your career or your approach to the subject, to the litigants, and if yes, how? And how do you manage that with your workload and everything?
Before I answer that, I must tell you how I got interested in music. I used to live in Dharapuram. I used to go to the board high school, a Tamil medium school.
So Dharapuram is Tamil Nadu only?
Yes, Tamil Nadu, in Coimbatore district. Today I think it is a separate district or in part of Erode district. There used to be a Anjaneya temple. Every year there used to be a car festival, Ter. So temple festival, and lots of artists will come, Karguchi, Arnachalam. I used to listen to music, but thereafter I got involved in not only Carnatic music but Hindustani music. I was fascinated by Kumar Gandharv. So then my friend Mukul Mudgal, who is from the family of which has actually started the institution Gandharv Mahavidyalaya. So I got very close to them. So today I am the president of Gandharv Mahavidyalaya Sharmgan Sabha in Bombay? In Delhi.
Oh, in Delhi.
There's
Delhi also?
Delhi also.
Okay.
So I have Bharatiya Vidya Bhavan. Bharatiya Vidya Bhavan has a lot of concerts. So I am involved in Bharatiya Vidya Bhavan. I am the president of the school and college managing committee in Delhi. So I think as persons who have reached certain position, I owe it to the society to give it back. And these are part of the things. So I try to devote time for all these, and whatever I can do, I certainly do.
And have you seen it affect your approach? Has it, because I feel I have a background in classical dance, not in music, but I really genuinely think that has really helped me as a person.
Yes. I think to keep equanimity, I think it helps. As a lawyer, it's important. You see, when you there are cases where there can be you may be arguing points which are completely unacceptable to the judge. Therefore, you will sometimes you face a hostile judge, and you cannot raise your voice. You should not, as a lawyer. As a good lawyer, one would not. And to maintain that even temperament and equanimity, I think all this kind of music, etc., does help in maintaining that, keeping that balance.
I think so. We did 5 productivity tips. Now 4 books that you would like to recommend. Need not be law books. It could be anything.
One is Tirukkural.
Tirukkural. Oh, okay.
I think nobody can put it, very concise, just 7 words. The way Thiruvalluvar has conveyed whatever he wanted to in just 7 words is something very remarkable. And management theories. இதனை இவனால் இவன் முடிக்கும் என்றாய்ந்து அதனை அவன் கண்விடல் is one of the Thirukural, which is, if you find that assess the competence of a person. If you find him competent, then you leave the job to him. That is theory of delegation in management.
Correct.
So this is something which is spoken about more than 2000 years ago by Thiruvalluvar. So you find in regard to taxation, in regard to king's rule, in regard to love, in regard to various things he has spoken about. Therefore, everybody, I think, should read that Thirukural. It's very important. And it's available in
English as
various languages. Second, I think, is the Discovery of India by Jawaharlal Nehru. Something which is very missing. Of course, today you have updated versions, including in regard to some history written recently by various other people. William Dalrymple's Golden Road, that's something which one can read. I would also recommend a book, Small is Beautiful.
Acha.
Today everybody talks about 5 trillion GDP, etc. The Shoemaker talks about economy where it's village economy or panchayat economy, how it's self-sufficient. And that's the kind of thing that in fact the government in Kerala is trying to do to some extent. Compared to other states, they are doing it. I'm not saying that's the best. Where they are trying to give the funds to panchayat and municipalities and having local self-government and trying to encourage all the women, everybody to be self-employed, so that kind of thing. So that's a book that is something which one should. Then our Harari, Sapiens. That's a book which is remarkable.
Yes.
So I given you 4 books.
You gave us 4. Even Justice Sridevan spoke about Thirukural.
Yeah, I kept away from all law books.
I agree. Thank you. And my last question, I think, to close out this section of the podcast is, when you reflect back on your life and you want to leave a legacy for the profession and the professionals that are coming after you, what would you want your legacy to be?
One, I think if people think that I have been a true professional, honest to the court, I think that's something that is I would treat it as a compliment. More importantly, I think the legacy that I am leaving is in the form of training people. Fortunately, some of my juniors have been able to achieve positions of importance. 2 of them have become judges of Supreme Court.
Okay.
Justice Ravindra Bhatt, who is now retired. Justice Vaidyanathan, who is presently a judge and in the normal course should become a Chief Justice of India in 2030. They have been my chamber juniors.
Okay.
There are also other persons who have become judges of High Court, Chief Justice of High Court. So this is something, and I have been having juniors who have become senior advocates, and I have always tried to maintain a balance. You have Mohana, Haripriya, they are senior advocates. You have Guru Krishna Kumar. People not just males but of
Women
both
as well,
sexes, females also. And they have become successful senior advocates. I think I'm happy about that. And in this I have followed Mr. Venugopal because Mr. Venugopal's office has produced the maximum number of senior advocates in the country.
Okay.
So
hardly surprising, but
yes. So that's something that I am happy about. And yes, by and large, today, if I'm considered as a person whose appearance in court, by the judges will feel okay. Here is a person whose statement of facts will not be incorrect. I think that's what people say, and that I think is quite a compliment for me.
True. I agree. So first is 5 productivity tips. So you mentioned time management. So I'm interested in knowing your answer to this.
Okay. Yes, time management is important. Punctuality. If I give an appointment at 5 o'clock, I will be ready at 4:55. Not at 4:55. I don't like to make people wait. I normally, I am very particular about that. If I am going to be late for some unavoidable reasons, I always communicate in advance. I am very particular about. Time management, yes. Thirdly, never postpone. I remember the days when in Delhi when I shifted, those days communication was only by post. I'm talking about 79, 80. Even telephone, long distance communication, it has to be trunk calls. So the lawyer and the client will be anxious. They send the papers by post and want you to file the matter in Supreme Court. Now, the moment I receive any communication, the same day a reply will go. The client may not even have telephones, but at least a postcard saying that yes, the papers have been received. The same evening, I'll go through all the papers and dictate my synopsis and ask my juniors to prepare the petition. I don't keep it for the next day. I never kept it for the next day. That's how I have followed it as a matter of policy. Whenever any thing comes, as far as possible, try to dispose it of the same day.
But how do you manage with the workload?
Yeah, but that's the time management. I think you have to, and secondly, don't undertake things which you can't do. So if you feel that you are being overloaded, then don't take up. Yes. Take up only so much that you can handle without affecting either your physique or health, without putting too much pressure on you. It's something which you learn, and I think this is very, very important, because from the point of view of the client's interest, that's something which needs to be done. Then fourthly, I would say be brief in your arguments. One of the biggest bane today in courts is the long-winded argument. So as an advocate on record, and I became an advocate on record in 79 and continued till 92. 92 I became a senior advocate. So my synopsis for the Supreme Court in most of the specialty petition was 1 page or 1.5 pages. If I can't put over a case in 1 page or 1.5 page, then that means I'm not worth the salt. The judges don't have such a long time to go through all the papers. If you have a genuine case, you must be able to put it over in 1 page of synopsis. Thereafter, you have long grounds. So this you must do. I have always believed in that. I have tried to train my chamber associates in this manner, that be brief. In the court also, when I open a case, I normally give a synoptic view in the first 5 minutes, so that they are able to appreciate, and then start giving them whatever are the facts, etc. Because that's, today judicial time is so precious.
Yeah.
We shouldn't waste it. So these are some of the things which I will.
Yeah. So we spoke about 5 productivity tips. But this one part that I think I want to know your view is about judicial delay. Because you just said that the court's time is very precious.
Yes.
Because I would assume judicial delay is a real problem. How do we...
See, it's not capable of a simple solution, but there are 3 or 4 things which have been talked about repeatedly. One is mandatory mediation. Second, imposition of heavy costs on frivolous litigation. Thirdly, increasing the judge strength. See, presently we have 14 judges per million people. Wow. Whereas the Law Commission 30 years ago said it should be 50 judges, 50,
wow,
for every million. So we are having a shortfall. Fourthly, even the judicial strength of 14, which we are supposed to have, that's a sanctioned strength, we don't all the time have, because invariably we have 60 to 70% occupied, 30 to 40% vacant. Vacancies are not filled up in due time. This not only in High Court, but in subordinate court, sometimes even in Supreme Court. These are some of the things, and I think the provision of ad hoc judges, which is contemplated by the Constitution, that has not been implemented. I don't know why the Chief Justices are reluctant. They are persons who have a lot of experience and who can be asked to sit and dispose of at least the criminal matters where the persons are undergoing sentence in the jail. So these are some of the things that have been talked about but have not been implemented.
And can we hope that it will be implemented?
I hope it is implemented, and see, it's not just number one, criminal procedure. It's both union and states have the competence. States can take the initiative also. It's not necessarily only the Union of India. Second, I think the High Court Chief Justices can also take initiative, not just from the Supreme Court. All these persons should be in a position to take. And I think the training, we need trained cadre of judges. We therefore need to even have, after a basic law course, I think we need to have a separate course for training persons to become judges, because one of the things judges definitely should learn about is in regard to judgment writing. There is no point in having 400, 500 page judgments. I simply do not accept that any case needs a 400, 500 page judgment. It should be possible to put over a judgment in 550 to 75 pages maximum. Even the most complicated cases, it should be possible. And if somebody is doing it, it is out of sheer laziness to apply their mind and to correct and prune down and have breezy writing. It's only that. I personally believe that there has to be a serious effort to reduce the length of judgments.
Yeah. I think two awards of former Supreme Court judges have been set aside in the Singapore High Court in the recent past. Arbitral about, it's a bit of a sorry figure that we are cutting.
Shameful.
Yeah. 3 tips for law students or young lawyers.
3 tips
for your law students, young lawyers, old lawyers also.
Number one, I think as a lawyer, divorce yourself from the case. Don't get identified with the case. So that professional integrity will be there only when you don't identify yourself with the case. Number one. Number two, what I have already mentioned about communication with the client, which is important. See, in India, not many people are aware of what exactly of the legal nuances. Just like you go to a doctor, most doctors are not communicative. The patient doesn't know what are the actual tests being done, results, and what procedure is being adopted. This communication is lacking in the between a doctor and a patient, equally between a lawyer and a client. I think that's another thing. You must communicate with a client. Explain to him whether he has a chance of succeeding or not, and be frank about it. And 3, you must be fair to the court. Be fair and honest to the court. These are the, if you wanted 3 tips, these are.
But how do you balance being fair? When you say being fair and honest, even if there's anything wrong with in your matter.
See, we have a system of adversarial jurisdiction, adjudication. So the other side is likely to point out, but you can't present a case which is wrong on facts. Very often what you do is, you may not, you will highlight all the good points in your case, may not speak
about the
overlook a sort of case, but the other side is there to point out. But when it is ex parte, you have a duty to point out. Secondly, you have a duty to present both sides of the law, even though it is adversarial. You can't possibly deliberately suppress from the court a judgment which is against you. I think this is, if there is a judgment against you, you have to explain to the court, this is the judgment which perhaps may not be right, therefore you may have to reconsider that.
Okay. And you also mentioned about when you were giving, talking about don't say yes to all matters. When you are talking about how to manage your time, or what are the ways that we can possibly overcome, what are the reasons why we have judicial delay. One of the things you said is don't say yes to all matters. Now, any young lawyer or even like mid-level, we all want to, because this is our bread and butter. In many ways, we are also like daily wage earners, right? You don't know where next month you have a salary or not. How do you balance that then?
I think, see, for example, in the Bhopal matter, when I was asked to appear for Union Carbide, I said no, that my conscience would not allow me to appear in a matter. So I didn't appear. I appeared, in fact, for the Union of India in the review matter subsequently. But even earlier, when I had been asked, I said no, I will not appear for Union Carbide. I mean, there are some cases where you would not appear. This is one of those matters. Like that.
And in terms of time management, when you said, okay, I'm having so much of volume of work, I want to still come, I get a brief, I want to finish off the synopsis by tonight. But I already have like 4 matters today, 2 matters today.
Sometimes yes, you have, but if you can, if it is not urgent and if it can wait, in the next 2-3 days, yes, you can. Sometimes you take up, so you do.
I mean, you prioritize. But this is, I think, one thing that all of us struggle with. Like,
you must always have an ABC categorization and the priority. Yes.
Okay. And 2 life lessons that you have learnt in your life so far.
One, don't be comfortable in whatever position you are. Be willing to be bold to take risks. So I could have continued in a job which was it was a prestigious job, but I was in DCM as a senior management trainee. I was secretary of the Vanaspati plant. That was not giving me soul satisfaction, so I quit. And I became a lawyer because I had seen the arguments during the Keshav Bharati, and I wanted to become a lawyer. So take risks. Be willing to burn the bridges and move forward. I had set up practice in Madras and I was establishing myself. like everybody else, I could have said no to come to Delhi, but I gave it up and came to Delhi.
And started again.
Yeah, fresh.
Yeah.
And in 92, I had the choice either to continue as an advocate on record. I was having at that time 12 to 15 juniors, running a fairly successful office, filing a number of cases as an advocate on record, matching with some of the big solicitors firms. But when a judge said that you should become a senior advocate, I said yes. I opted to become a senior advocate, so I wound up my office. These are things that I took a risk. I knew I was taking a risk, but you have to. If you don't take a risk, then you are not in a position to. I think move forward, and then that's something. That's a life lesson that I have learned. Second, I think is you have to, be giving time not merely to the profession, but I have friends today with whom I have studied in 1956-58. I have contact with all my relatives. So I try to keep in touch with persons who have been my schoolmates, college mates, hostel mates, and during the time of employment who were with me. So we are on WhatsApp groups, we keep in touch, and with relatives, because we come alone and go alone. But during the time we are here, we must be in touch with. This is some lesson, because ultimately that's what gives you the comfort.
Yeah.
That's what makes you happy.
Yeah, lovely. And the last question is the one best piece of advice you have ever received in your life?
I think, as I mentioned earlier, from my father, be true to yourself and therefore be true to the court. Never, and don't be respectful at the same time. You don't have to be kind of subordinate. Therefore, press your point with firmness, and at the same time be respectful to the court.
Lovely. Thank you, sir. Thank you so much.
Thank you for the questions, and I'm happy I was in a position to share with you some of my
experience. So much of.
Yes.
Thank you so much.
Thank you, Jana.
You were very it was such a candid, comfortable chat. I hope you have had a good time.
Thank you.
I had a great time.
Thank you.
Thank you, everyone, and I hope please keep following us and like and subscribe and do all of that. I hate this part. I just hate it. I'm not going to say all this. If you tell me you're not telling the truth. Okay, bye.